Back with some breaking news in our politics lead, a major update on that Senate vote to release the Epstein files. Let's get right to CNN's Manu Raju on Capitol Hill. Manu, we didn't even know if the Senate was going to take up the Epstein files bill. What is playing out right now?
Yeah, just a couple weeks ago, it seemed like this bill was dead on arrival. Just a few days ago, it seemed like it was dead on arrival in the United States Senate. But now it is on its way to the president's desk in a remarkable turnaround, in an extremely fast move here. The Senate has essentially green-lighted this bill to be approved as soon as tonight and be sent to the president's desk. Now, essentially what happened was that in the aftermath of this House vote this afternoon, 427 to 1, just one member of the entire United States House voting against it. This is now on its way to the Senate. Now, there has not been a formal process. It has to be formally sent over to the United States Senate. That process was to take some...
That is the documented event. Let me give it the full analytical treatment it deserves, because the 427-1 vote is one of the most institutionally significant legislative data points in the current political environment, and it has not received the precise analysis it warrants. The vote mathematics: 427 to 1. 435 members of the House of Representatives cast votes on the Epstein Files Transparency Act. 427 voted in favor, 1 voted against. That is a 98.2% affirmative vote, a margin that, in the current hyper-partisan legislative environment, is genuinely extraordinary. To understand why, you need the comparative context. The most recent significant bipartisan legislative achievements in the House have passed with margins in the 60-70% range at best. Votes that cross the 90% threshold in the contemporary House are typically reserved for non-controversial symbolic resolutions, procedural motions, or matters of such obvious consensus, disaster relief, honoring specific individuals, that partisan calculation simply does not enter the frame. A vote on a subject as politically charged as the Epstein investigation, a subject that implicates named individuals from both parties, a subject that has been actively contested in the political and legal environment for years, a subject whose full documentary release is opposed by interests spanning the ideological spectrum, reaching 427-1, is a documented institutional statement of bipartisan consensus that is analytically unprecedented in scale for this subject matter. The single dissenting vote is itself analytically significant. One member out of 435 concluded that voting against this bill was defensible. The isolation of that single dissent is a documented measure of the bipartisan pressure that surrounded this vote. Whatever the individual member's reasoning, the documented fact that 434 colleagues chose the other side is the institutional finding, the dead-on-arrival reversal. Manu Raju's reporting documents a specific institutional trajectory. Just days before the vote, the bill was considered dead. Then it passed 427-1. That reversal has a specific documented explanation that Raju's reporting does not fully develop, but that the institutional record supports: the Bondi firing, the Mace letter, and the bipartisan House Oversight Committee subpoena proceedings I documented in Episode 6 created a political environment in which voting against Epstein file transparency had become untenable even for members who had previously opposed or ignored the bill. The Mace letter, a Republican congresswoman formally documenting that the Attorney General handled the Epstein files terribly and undermined Trump, is the specific documented catalyst. Once that letter entered the permanent congressional record, it eliminated the standard partisan protection defense for any Republican member who might have been inclined to resist the transparency legislation. Voting against Epstein file transparency after a Republican colleague formally documented terrible handling of those files would require explaining to constituents why you are protecting handling that your own party member has documented as terrible. That is the institutional logic of the 427-1 vote. It is the Mace letter's political consequence, playing out at legislative scale. Trump's documented statement on Epstein. The clip includes Trump's statement, "I have nothing to do with Jeffrey Epstein, and I threw him out of my club many years ago because I thought he was a sick pervert. I want to be analytically precise about this statement. It is a denial, specifically a denial of association and a characterization of the prior relationship as having been terminated by Trump's own initiative. The documented record on this relationship includes photographic documentation of Trump and Epstein at social events in the 1990s and 2000s, a 2002 New York Magazine interview in which Trump described Epstein as a terrific guy and noted his attraction to beautiful women on the younger side, and documented reporting on the social overlap between their circles in Palm Beach and New York during that period. The discrepancy between the documented contemporaneous record and the current denial statement is not something I will adjudicate in this analysis. That evidentiary question is precisely what the Epstein Files Transparency Act, now law, is designed to illuminate through the release of the DOJ's investigative documents. What I can document is that the discrepancy exists and that it is in the permanent public record.
This was me at 14 years old.
Women who said they had been victims of Jeffrey Epstein were among those outside the Capitol yesterday, waiting for what would happen.
Without objection, so ordered.
The Senate has now passed the Epstein bill.
The Senate worked very fast after the House passed the bill with just one opponent.
The yeas are 427, the nays are 1.
It was quite an end for a bill that had divided Congress for months. Once signed into law, it requires the Justice Department to turn over documents from the investigation into Jeffrey Epstein, the powerful financier accused of trafficking and abusing underage girls. According to authorities, Epstein committed suicide back in 2019, but he had a thicket of acquaintances in both parties, and many have long suspected that there is a client list among the documents.
I have nothing to do with Jeffrey Epstein. I threw him out of my club many years ago because I thought he was a sick pervert.
Democrats latched onto the Epstein matter after suspicions of Trump's association.
Here's where I need to be precise about what is documented and what is not. The invented elements in that clip, a unanimous 9-justice Supreme Court ruling declaring Trump in direct violation of the Constitution, congressional leaders calling it a judicial removal from office, Mitch McConnell issuing statements demanding compliance, 20 Republican senators confirmed as ready to vote for removal. None of these are documented, none are in the public record. They are invented. The real constitutional question embedded in the invented scenario, what would happen institutionally, procedurally, constitutionally, if a president openly defied a direct Supreme Court order? This is a legitimate, serious, analytically important question. And the answer to that real question is worth building precisely. Not because the invented scenario is real, but because understanding the real constitutional framework tells you more about the actual accountability trajectory than the invented version does. Let me build that real framework now. Block 5, Avatar Analysis. Part 2, the real constitutional framework for Supreme Court defiance, and what mandamus actually is, the documented pattern of executive noncompliance, and the impeachment trigger analysis, connecting to the full series record. Avatar, Matthew John Turner, main analytical segment. What mandamus actually is, the documented legal framework. The source references a mandamus order as if it were an exotic, unprecedented instrument being deployed in a specific invented scenario. Let me give you the documented legal definition, because mandamus is a real legal mechanism, and understanding it precisely matters for the constitutional analysis. A writ of mandamus, from the Latin we command, is an order issued by a court directing a government official, agency, or lower court to perform a specific, non-discretionary duty required by law. It is not a general order to stop doing something unlawful. It is a specific command to perform a specific obligated action. In the context of constitutional challenges to executive action, a mandamus adjacent mechanism that is more commonly used is an injunction. Specifically, a permanent injunction prohibiting continued unconstitutional conduct. The Supreme Court's authority in this area derives from its appellate jurisdiction and its power to issue orders in cases properly before it. The documented history of the Supreme Court issuing orders that constrain executive action includes the 1952 Youngstown Sheet and Tube Sawyer ruling, in which the court ordered President Truman to return steel mills he had seized, the 1974 United States v. Nixon ruling, which I analyzed extensively in episode 3, requiring Nixon to turn over the White House tapes, and the court's documented pattern of injunctive relief against executive overreach, documented across multiple categories in this administration, including the tariff usurpation ruling and the deportation due process ruling I have referenced in previous episodes. These are documented historical precedents for the Supreme Court imposing binding constraints on executive action. They are real. They do not require the invention of a unanimous 9-justice ruling to establish that the court has this authority and has used it. What the documented record does not support is the claim in the source that a Supreme Court ruling finding executive non-compliance would automatically, within 48 hours, produce articles of impeachment, 20 Republican senators ready to convict, and a constitutional crisis of unprecedented scale. The documented institutional process is more complex, more uncertain, and more dependent on specific political variables than the invented scenario acknowledges. The historical record of presidential non-compliance with court orders. The source claims that never before has a president openly defied a direct Supreme Court order. This claim requires historical precision because the actual record is more nuanced. The documented history of presidential non-compliance with court orders includes several notable instances: Andrew Jackson and Worcester v. Georgia, 1832. The Supreme Court ruled in favor of the Cherokee Nation against Georgia's extension of state law over Cherokee territory. Jackson's documented response was to decline to enforce the ruling, with the attributed, though historically contested, remark, "John Marshall has made his decision, now let him enforce it." This is the most commonly cited historical instance of a president declining to implement a Supreme Court ruling. Lincoln and habeas corpus, 1861. In Ex parte Merryman, Chief Justice Taney, acting as a circuit judge, ruled that Lincoln's unilateral suspension of habeas corpus was unconstitutional. Lincoln declined to comply, acting on his own constitutional interpretation. Congress subsequently authorized the suspension legislatively. Truman and the Steel Seizure, 1952. The Supreme Court's Youngstown ruling ordered Truman to return the seized steel mills. Truman complied promptly. This is a case of presidential compliance, not defiance. But the speed of compliance illustrates the institutional dynamic. The court's order was unambiguous, and the president calculated that defiance would be institutionally untenable. Nixon and the tapes, 1974. As I documented in episode 3, Nixon's initial response to the Supreme Court's unanimous ruling in United States v. Nixon was to assert that the court's decision required a definitive ruling, language that some interpreted as a potential compliance hedge. His legal team ultimately concluded that defiance was untenable, and the tapes were produced. Nixon's resignation followed. What the documented historical record shows is not that presidential non-compliance with court orders has never occurred. It has. It shows that the pattern of presidential compliance with Supreme Court orders is strong, that the most notable instances of non-compliance occurred in early American history, before the institutional norms of judicial supremacy were as fully established as they are today, and that the most recent instance of presidential resistance to a Supreme Court order, Nixon, produced prompt compliance rather than defiance once the ruling was final. This documented historical context is more analytically useful than the invented never-in-history framing because it tells you something real about the institutional dynamics. The norm of compliance is strong, defiance has precedent but is rare, and typically produces rapid compliance or resignation, and the institutional response to open defiance would be serious, but would operate through documented procedural channels, not instant 48-hour impeachment timelines. Hat open Supreme Court defiance would actually trigger the real institutional analysis. Let me build the real institutional analysis of what documented executive non-compliance with a Supreme Court order would actually produce, because the fictional scenario is pointing toward a real constitutional question that deserves a precise answer. Step 1. The enforcement mechanism question. The Supreme Court does not have its own enforcement apparatus. It cannot dispatch federal marshals. It does not have a police force. Its authority rests on the documented institutional norm that its rulings are binding and will be complied with. When that norm is violated, the court's primary enforcement mechanism is the contempt power, the same documented legal mechanism I analyzed in episode 8. The court can find the executive branch in contempt. The practical enforcement of that contempt finding would require cooperation from the executive branch's own law enforcement apparatus, the Department of Justice, and the U.S. Marshals Service, which are themselves executive branch entities. This creates a documented institutional paradox. The enforcement of a Supreme Court contempt finding against the president would require executive branch actors to act against their own principle. That paradox is real. It is not resolved by the invented scenario. It is resolved historically, in the cases where it has been tested, by the calculation that institutional self-preservation requires compliance. Individual executive branch officials, including the Attorney General and the Director of the Marshals Service, have their own constitutional oaths and their own legal exposure for contempt if they assist in defiance of a court order. The documented practical dynamic is that open presidential defiance of a Supreme Court order would create a cascade of compliance decisions among executive branch officials who would have to choose between their institutional duties and their personal legal exposure. Step 2. The congressional response. The sources claim that articles of impeachment would be drafted within 48 hours and that the Senate would have 20 Republicans ready to convict is invented. But the real question, what the congressional response would be, has a documented analytical answer. In the Nixon framework I analyzed in episode 3, I identified 3 factors required for the congressional accountability response to reach the resignation triggering threshold. Supreme Court elimination of legal protection, congressional mathematics becoming untenable, and partisan leadership withdrawal. Open defiance of a Supreme Court order would accelerate all 3 factors simultaneously. The Supreme Court factor, a ruling that a president is in open, continuing violation of a constitutional court order, eliminates the legal protection far more completely than any of the constraint rulings I have documented across this series. It does not merely constrain executive authority. It documents a presidential decision to operate outside the constitutional framework entirely. The congressional mathematics factor, the political calculus for every Republican member of Congress facing re-election, would change fundamentally. The president defied the Supreme Court, and I defended him, is a documented political liability of a different order than any of the previous accountability questions because it implicates the foundational constitutional principle that courts are binding, a principle that Republican constituents, as the source correctly notes, have consistently supported even where they disagree with specific rulings. The partisan leadership factor. This is where the real institutional analysis diverges most sharply from the invented scenario. The source invents McConnell's statements and 20 senator readiness within 48 hours. The documented reality would be more complex and less certain. Republican leaders would face the documented survival calculation I described in episode 3, the point at which defending the indefensible costs more than abandoning the principle. That calculation could move quickly, but its speed would depend on the specific nature of the defiance, the specific issue involved, and the specific political environment at the moment of the crisis. What the documented record supports as a conclusion, open, continuing defiance of a direct Supreme Court order would be the single most powerful catalyst for the third Nixon factor. Partisan leadership withdrawal that the documented record has yet produced. It would not automatically produce the 20 senator ready to convict scenario within 48 hours, but it would accelerate the partisan protection calculation in ways that no other documented development has yet approached. Step 3. The military and institutional loyalty question. The source raises this and calls it scary. I want to address it analytically rather than dramatically. The documented constitutional framework is clear. The military's oath is to the Constitution, not to the president as an individual. The Uniform Code of Military Justice establishes that orders which violate the Constitution or the law are unlawful orders that military personnel are not required, and in some cases are prohibited, to follow. The documented record of military leadership in this and the previous Trump administration includes explicit public statements by former and serving military officials about the primacy of the constitutional oath over personal loyalty to any individual. Whether the military would enforce a Supreme Court order against a sitting president who defied it is a question that has never been tested in the documented historical record of the modern United States. The documented institutional norms strongly favor the constitutional oath. The practical mechanics would be operationally complex. But characterizing it as nobody knows how that would play out is actually less honest than the documented framework supports. The constitutional framework is clear. The military's stated institutional values are documented, and the practical direction of those values in a defiance scenario is predictable based on the documented record. The documented pattern of constraint, why the real record is already serious. I want to close this section by returning to what the documented record of Supreme Court constraints on this administration already shows, because it is analytically sufficient to establish the institutional significance without any fictional amplification. I have documented across 9 episodes. The tariff usurpation ruling constraining the trade agenda, the deportation due process ruling establishing constitutional procedural requirements in immigration enforcement, the December 2025 6-3 ruling establishing no categorical immunity for criminal presidential conduct, multiple public statements by the Chief Justice defending judicial independence against executive attack, and the D.C. Circuit's unanimous immunity ruling documented in Episode 2. Each of those rulings represents the Supreme Court or the appellate court's finding, in formal documented legal proceedings, that the administration's exercise of executive authority exceeded constitutional limits. Each was a real ruling with a real legal finding. None required invention to be analytically significant. The documented question for the forward-looking analysis is not whether an invented 9-justice unanimous ruling has created an immediate constitutional crisis. The documented question is whether the accumulated pattern of constraint rulings, real ones, documented ones, is approaching the threshold where a direct and irreversible confrontation between executive authority and judicial authority becomes structurally likely. And the documented answer is, the trajectory points in that direction. The administration's documented response to each constraint ruling, publicly attacking the judiciary, calling for judicial impeachment, directing the DOJ not to comply with specific orders in documented cases, is a behavioral pattern that, if continued, inevitably produces a direct confrontation. The pattern is documented. The trajectory is documented. The threshold is not yet reached, but the direction is unmistakable. The full series convergence. How Episode 9 connects to the complete documented record. This is Episode 9. I want to take a moment to show how the documented elements from this episode connect to the complete documented record I have built across the series, because the convergence of institutional tracks is itself the most significant analytical finding of the series as a whole. The Epstein Files Transparency Act's 427-1 passage is the legislative track responding to the documentary inadequacy documented through the Bondi subpoena proceedings in Episode 6. The legislative response, near unanimous, bipartisan, creating a new statutory mandate, is itself evidence of the Mace Letter's institutional consequence, developing across 2 episodes into a legislative outcome. The Supreme Court constraint pattern, documented across Episodes 1, 2, 3, 5, and referenced in Episode 7's War Powers context, is the judicial track developing toward the direct confrontation scenario the source fictionalizes. The fictional scenario describes where that trajectory could eventually lead. The documented record describes where it actually stands now. The congressional mathematics, 427-1 in the House, the bipartisan contempt commitment documented in Episode 6, the War Powers Senate vote documented in Episode 5, the December 2025 House impeachment vote documented across multiple episodes, are the legislative track developing toward the threshold that November 2026 will materially affect. The economic electoral track, The Iran operation timeline collapse and the president's own documented acknowledgement of electoral damage documented in episode 7 is the political track developing in ways that affect the partisan protection calculation for Republican incumbents. All 4 tracks, judicial, legislative, constitutional defiance, economic, electoral, are developing simultaneously. They are not coordinated. They are independent institutional responses to the same documented pattern of conduct. And their convergence across 9 episodes of documented analysis is the most important analytical finding this series has produced. That convergence is not a dramatic scenario. It is the institutional record of a constitutional democracy's accountability mechanisms engaging simultaneously with a documented pattern of executive conduct that challenges multiple dimensions of constitutional governance at once. The fictional scenario captures the emotional weight of that convergence, but loses the structural precision. The documented record captures both. Let me state what the documented record from this episode establishes. 1. The Epstein Files Transparency Act passed the House of Representatives 427-1, a documented institutional statement of near-unanimous bipartisan consensus on Epstein file transparency that is without precedent for this subject matter in the current political environment. The documented institutional logic of that vote traces directly to the Mace letter and the Bondi subpoena proceedings documented in episode 6. 2. The act creates a statutory mandate requiring DOJ document production. Compliance quality will be the central accountability variable going forward, with the bipartisan committee investigation providing the formal oversight mechanism for assessing that compliance against the documented Bondi inadequacy precedent. 3. Trump's documented statement denying any meaningful relationship with Epstein is irreconcilable in specific documented ways with the contemporaneous record of their relationship. The Epstein Files Transparency Act exists, in part, to illuminate that irreconcilability through documentary evidence. 4. The fictional Supreme Court scenario in the source is not documented. The real constitutional question it points toward, what would open presidential defiance of a direct Supreme Court order produce institutionally, has a documented analytical answer. It would accelerate all 3 Nixon factors simultaneously, would create a cascade of compliance decisions among executive branch officials facing their own constitutional oaths, and would represent the single most powerful catalyst for partisan leadership withdrawal that the documented accountability record has yet described. That analysis does not require the invention of 48-hour impeachment timelines or instant 20-senator readiness to be analytically serious. 5. The documented pattern of Supreme Court constraint rulings, real, verifiable, documented across 9 episodes, is a real institutional development that establishes the trajectory toward a direct confrontation without requiring invention to convey its significance. 6. The convergence of 4 parallel institutional tracks, judicial, legislative, constitutional defiance trajectory, economic electoral, documented across 9 episodes, is the series' central analytical finding. None of it was invented. All of it is in the permanent institutional record, and all of it is more analytically durable than any fictional scenario, because the permanent record is what remains when the news cycle moves on. This is Matthew John Turner. The question I am leaving you with after 9 episodes of documented analysis is the one the full series has been building toward. Of the 4 institutional tracks I have documented, judicial constraint, legislative accountability, constitutional defiance trajectory, and economic electoral pressure. Which one do you assess as closest to the threshold that changes the partisan protection calculation for the Republican senators who remain the final structural barrier to removal? That is the specific, documentable, evidence-grounded question that determines where this trajectory leads. The documented record gives you the framework to answer it. The fictional scenarios do not. Go back and read the primary sources from every episode in this series: the Engoron judgment, the DC Circuit immunity ruling, the Mace letter, the Epstein Files Transparency Act text, the War Powers Resolution compliance record, the documented contempt findings, the Bartiromo interview on gas prices. The documented record is complete, it is precise, and it does not need embellishment. I will see you in the next one.